Good evening and welcome once again to another program of Issues in the News, where we discuss the important events that would have taken place in our country over the past week or so. And as is the norm, we always have menu, a packed menu of issues that are worthy of discussion. This, this week is no different. And as is customary, I want to begin by greeting all of our viewers who are joining us in Region 5 from Mahaika to West Coast Berbice on television. Good evening. I want to also welcome all of our viewers who are joining us on television on the east bank of the Berbice River all the way to New Amsterdam. Good evening. And of course, from New Amsterdam all the way to Molson Creek, all of you who are joining us on television by the tens of thousands, good evening and welcome to another program of Issues in the News. To our listeners and viewers who are joining us on Freedom Radio, good evening and welcome to another program of Issues in the News. And last but not least, to the tens of thousands of you right across the length and breadth of Guyana, the Caribbean, North America, Europe, and of course, further afield who are joining us on Facebook Live. Welcome once again to another program of Issues in the News. And as I said, I want this program to be interactive, and I want you to share this program with as many persons as possible. So please press that share button on your phone, press that share button on your computer, so that all your friends and followers can become part of our audience. The widest possible audience we receive is best for the program. So once again, please share this program to all your friends and followers by pressing that share button on your phone or on your computer so that this program can be viewed by all your friends and followers. And as I said, I want this program to be interactive, so I see how many of you have already joined us. Anita Hardiyal, Patrick Sicharan, Garbaran Bisnot, Mavis, Bhagwandas, Arjun Jawahir, Pam Singh, Ronnie Singh, Bod Wahid, and so many of you, Dionan Alfred, Pamela Ramotar, and also remember to put your questions to me, pose whatever issues you wish me to discuss so that I can discuss it. Krishna Dan Paul, Matbar Singh from New Jersey, Shelly Ram Narain, Harry Gill, Suknanan Bod, Davindra Chetram, and so many of you. And the requests have begun to come in relation to what you want me to discuss. And that's what I want so that we can be constructively engaged. Well, the biggest item on today's agenda, the major news event occurring today, is the landmark ruling of the Honorable Chief Justice Roxanne George Senior Counsel in the case filed by Mr. Aubrey Norton challenging the appointment by His Excellency the President of, firstly, the Chairman of the Police Service Commission, and secondly, the members of the Integrity Commission. The leader of the opposition contends in his legal proceedings that the President did not comply with the Constitution and did not comply with the Integrity Commission Act in so far as both create upon the President a duty to conduct meaningful consultations with the leader of the opposition before those appointments can be made. The leader of the opposition contended that he was not meaningfully consulted in accordance with the Constitution or the Integrity Commission Act. And of course, we had to file a defense to the case, and we had to put forward our evidence in support of our defense. We contend that the President followed the letter and spirit of both the Constitution and the Integrity Commission Act in consulting with the Leader of the Opposition. We exhibited to the court a series of letters which were exchanged between Minister Gail Teixeira on behalf of His Excellency the President, yours truly on behalf of His Excellency the President, as well as letters that came in response from the Leader of the Opposition. We also detailed the fact that the Leader of the Opposition attended an in-person meeting to discuss these consultations, and also was invited to another meeting which he chose not to attend. The letters were examined carefully by the Chief Justice, and those letters established clearly, firstly, that the President sent the names of the persons for the respective commissions with whom he wished to consult with the opposition, and a date was fixed for an in-person meeting immediately from the beginning of the consultation process. The Leader of the Opposition wrote and said that he wants more information. Gail Teixeira responded and provided the CVs of the persons whom were the subject of the consultations, and inquired of the Leader of the Opposition to furnish whatever information he requested, additional information he requested. Then the in-person meeting came. At the in-person meeting, it was drawn to the leader of that in-person meeting was attended by His Excellency and yours truly, as well as the Leader of the Opposition and Mr. Roysdale Ford, lawyer in the matter. At that in-person meeting, it was drawn to the attention of the opposition leader that he's asking for more information in addition to the CVs. And we inquired of him at that meeting what other information he requests. He said that all the information that he requested were the CVs. The CVs were then furnished to him as he requested, clarifying that that's all the information that he needs. They were sent to him in 48 hours. At that in-person meeting, a joint statement was prepared by myself and Mr. Ford with the concurrence of His Excellency the President and the Leader of the Opposition, and was sent out publicly. And in that statement, we put in that statement that the only information that the Leader of the Opposition has clarified that the only information he requests is the CVs of the persons who are the subject of the consultation. That, as I said, were supplied to him. And then he was invited to another meeting. And in that letter that invited him to the other meeting, we informed him that in the event that you are unable to attend, please make your contribution in writing. He never turned up to that meeting, and he sent a letter an hour after the meeting was supposed to be started. And in that letter, he then makes a new set of requests. He wants the basis for the recommendation, and he still asks for additional information so that he can make an informed opinion, not stipulating again what this additional information is. And after he was absented from that meeting, which he was invited, and he didn't supply any additional information, he didn't make any additional contribution, the President, through Gail Teixeira, wrote him once again and said, we have come to the conclusion that you have no other contribution to make, and we are satisfied that the Constitution, in relation to meaningful consultation, was satisfied in respect of the appointment of the chairman of the Police Service Commission, and in relation to the Integrity Commission, the Integrity Commission Act was also satisfied. And that is when they filed proceedings. Of course, all kinds of arguments were raised, and we replied to every single one of them. And the Chief Justice took her time and, using very civil language, lambasted the leader of the opposition for the manner in which he has approached the consultation, describing his conduct as uncooperative, identifying his conduct as not reciprocal, describing his conduct as not understanding his obligation in the consultative process, that the consultation process is not a one-way street, that it requires mutuality, it requires an input from both sides, that he failed to clarify what is this additional information he keeps asking for, that he did not furnish a single nominee of his own to counter the nominees put forward by the president, that he did not advance a single criticism during the negotiations or the consultations against any of the nominees of the president to suggest that they were unqualified or unsuitable. But after the consultation came to an end, and in the case itself, he starts to make up objections, and that was not countenanced and tolerated, and were rejected out of hand. And the Chief Justice spoke about the high responsibility that devolves both on the president and on the leader of the opposition when it comes to consultation, and that this consultative process must be engaged in a civil manner, and that he, Mr. Norton, was more confrontational than civil, and that he brought in to the negotiations and to the consultations highly extraneous matters. For example, that there should be an agreement that he, as leader of the opposition, is in agreement for the appointment of Roxanne George as the Chief Justice and Yonette Cummings as the Chancellor, a matter that was not part of the consultative process. And he was reprimanded and admonished for importing into the consultation process matters that were not relevant, because the office of the Chancellor and the Chief Justice were not part of this consultative engagement. And that was made clear to him long before in earlier correspondence. Yet, in his effort to obfuscate the matters at hand, he brought in extraneous matters and then started to abuse the president. One of his letters, the last letter that he wrote, was very abusive. And the tone of that letter was also condemned in the written ruling. The disrespect, and he accused the president of all manner of ill things, nothing to do with the matter at hand, which were whether these people that were under review were suitable and qualified for the posts under consideration. And this case, without more, demonstrates, in my respectful view, more than anything else thus far, that this leader of the opposition is incapable of discharging the high level of responsibility and duties which devolve upon that important constitutional office. I have never seen the judicial branch make such scathing remarks regarding a high constitutional office holder like the leader of the opposition in the manner expressed in this judgment. This guy only wants to be confrontational and only wants a papi show so that he can exhibit himself to the press. And that is what characterizes all his public engagements. I looked at him briefly today in a press conference, and the same type of confrontational approach I discern in relation to the journalists who are asking him questions. He holds a press conference, and then almost every question that is asked of him, it becomes a confrontational exchange between him and the reporter. Especially, which happens on a regular basis, he cannot sensibly answer the question posed to him. Every time he cannot answer the question posed to him, which occurs with alarming regularity, he becomes confrontational and deflects the questions. And he seemed to now have employed a strategy whereby at the appropriate time, he will speak on these matters. At the appropriate time, he will make the necessary disclosures and he will take the necessary action. Well, why don't you keep the press conference at that appropriate time? Why are you keeping press conferences now, trying to engage the public, and then when you are asked questions by the reporters relating to what you are speaking about, you are incapable of answering sensibly and then try to deflect attention as if it's a political strategy of yours that you will deal with the matter at an appropriate time, or you will take the requisite action at an appropriate time. Keep the press conference at that appropriate time when you're prepared to engage and divulge. The whole purpose of a press conference is to divulge information. You can't go to a press conference and when you're asked questions, you keep information to yourself. That simple thing eludes the leader of the opposition. And that is the kind of behavior that was evident in the case that he filed. And the Chief Justice made the appropriate pronouncements. I am going to get back to the case in a moment, but let me digress to speak about another issue that he spoke about at the press conference, to demonstrate that this gentleman has a conceptual difficulty in understanding concepts. He says at the press conference to a question posed to him by a reporter, speaking on the list, the electoral list, he says that he intends to keep pressure on the government in his objection to what he describes as a bloated list, and that he intends to keep pressuring the government about that list. This gentleman up to now seemed not to be able to grasp that the government of Guyana has nothing to do with a list of electors, that the Constitution of Guyana establishes an agency called the Guyana Elections Commission and invests in that agency the exclusive power and responsibilities to hold elections in Guyana and prepare for those elections, which preparation includes the compilation of a list of electors in accordance with the Constitution and the laws of Guyana. The government has nothing to do with that. What I and other members of the government have been speaking about and criticizing him in relation to, because he seems to want unconstitutionality to take place in relation to that list. And whenever he makes those wild, reckless, and unfounded allegations about unlawfulness of the list, then the government, being a stakeholder, is entitled to speak. But I am using this platform to call upon GCOM to speak about the list and to inform Mr. Norton and the public that there is a ruling from the Chief Justice while Mr. Norton's party was in government, when GCOM, under an illegal chairman appointed by President Granger, was attempting to remove persons from the list who were already registered. The Chief Justice of the country, we took proceedings to the court, and the Chief Justice pronounced that it is unlawful and unconstitutional to remove persons who are registered on that list unless they are disqualified on grounds laid down in the law. That once a person goes on that list, he can only be removed from that list upon grounds set out in the law, because he goes upon that list satisfying qualifications laid down by the law. And he can only be removed from that list by disqualifications laid down by the law. And the process is to be done by GCOM and not political parties and politicians. So Mr. Norton is obfuscating these issues clearly because he can't delineate them in his mind. So he has conceptual difficulties understanding the bifurcatory nature of these issues. These issues are for GCOM. And that is why I'm asking GCOM to respond to these issues and to explain to the public why they cannot remove registered electors at the whim and fancy of Norton. GCOM has to do that. But when this unconstitutionality is being peddled by Mr. Norton, every citizen of this country is entitled to pronounce upon them. And as a government, it is our duty also to speak against them. It doesn't mean that we want that position. Norton can't decipher these issues. So he confuses GCOM with government. He has 3 commissioners at GCOM. Let them explain to the public what the Chief Justice said about that list and the removal of names therefrom. Let them say that the Chief Justice is wrong, and let them explain why they did not appeal that decision. They could have appealed that decision if they are dissatisfied with it. But I give you that example for you to get an insight into the mental confusion of this opposition. So they didn't have a leader of opposition in place for the president to consult for the appointment of a commissioner of police. Yet, when the president makes the appointment, without consulting, because there is no one to consult, they took the matter to the court. And they were wrongly trashed, and rightfully so. Again, they did not want to participate, did not cooperate with the consultative process, made no constructive and significant contribution, although they were given many opportunities to do so, both in person as well as in writing. All you had was a glum request for more information, no specificity regarding what those information are, and when they were specifically asked, they said CVs, and when the CVs were given to them, they want more information afterwards again, but not saying what those information are. So the Chief Justice was perfectly in order. And to his credit, Ford complimented the Chief Justice in her ruling. So that was one part of the decision. The other part of the decision had to do with the composition of the Police Service Commission. Recall that there is no chairman of the Public Service Commission. The Police Service Commission requires, as part of the whole, a member, the chairman of the Public Service Commission. But there is no Public Service Commission yet appointed. And the Chief Justice essentially ruled that the Police Service Commission, because of the physical absence or the non-existence of the chairman of the Public Service Commission, that the Police Service Commission is not properly constituted. I beg to disagree with that part of the ruling. I don't share the Chief Justice's view, and I say so with the greatest of respect. 1 from 5 can't be 0. And the Constitution clearly says that 4 is a quorum and 4 can perform the functions of the commission. The Chief Justice doesn't hold that view. But importantly, we argued that assuming that the Police Service Commission was not fully constituted, we argued that the Commission's actions will be justified in law by invoking the de facto doctrine. The de facto doctrine is a doctrine in law that seeks to legalize actions and decisions made by any body or authority who is subsequently found, or which is subsequently found to be not properly appointed in the first place, or not fully constituted in the first place. So when, to counter that argument, I argue that assuming that the Police Service Commission, as they are contending, was not properly constituted, then the de facto doctrine exists in law and was created in law to deal with that type of situation. to legalize actions done by the Police Service Commission. And the Chief Justice accepted that submission. So all the promotions that they were trying to set aside, the police promotions that they were trying to set aside, the Chief Justice held were properly, were justified, and are valid and binding by invoking the de facto principle. So the government suffered no setback, for want of a better word, in the decision as a whole. But I, as I said, disagree with that one component. So the case is an important case, as the Chief Justice laid down for future guidance how the relevant players are to behave and conduct themselves when they are required to consult in accordance with the Constitution and any other law. So it's a good decision that will guide decision makers in the future when they have to do consultation. Very important decision. And it's a very important decision also because it examines very keenly the conduct of the leader of the opposition and chastises that conduct, not meeting the standard required of a responsible holder of that office, not discharging the reciprocal duty that devolves upon that office holder when engaged in the consultative exercise. As the Chief Justice said, using a colloquial expression, one hand can't clap. Meaning that a president can do everything that is required of him. But if you have a delinquent, recalcitrant, negligent, irresponsible leader of the opposition, then the consultation process can't be satisfied. And that is what happened here. The president alone can't do the thing. And when that happens, the president cannot be faulted. And all the case law authorities say that because it's a principle based upon mutuality. Mutuality, both sides. And if one side is misbehaving, the other side can't be faulted. And the consultative process cannot be faulted because one side or one hand is deciding not to clap. So I thought that I'll spend some time in explaining that decision. I had to clarify also that the ruling of the Chief Justice does not in any way affect the appointment of Mr. Clifton Hickin as Commissioner of Police acting. Because recall that after the leader of the opposition was appointed, the president began an ex post facto consultation in relation to his appointment and engaged the Police Service Commission in the consultative process as he is required to do in the Constitution. So after the Police Service Commission was found not to be properly constituted, the Chief Justice made some pronouncements in relation to that that may have led the public who are listening and the press who are present to think that Hikin appointment was somehow affected by this ruling. And I asked the Chief Justice a couple of questions to make it very clear, in particular for the benefit of the press, who may not understand the intricacies of the law, that her ruling today and what she says, or what she said, what Her Honor said about the Police Service Commission have nothing or did not have any impact whatsoever on the lawfulness of Clifton Hicken appointment, which was already pronounced by the court to be lawful and constitutional. So I want to clarify that for the benefit of the viewers so that you understand and we are not confused about anything. So let me check some of the comments that I am seeing here. Someone wants me to speak about the IDP. I'll speak about that. Someone is asking whether other ethnicities have an organization of that type. So that's not a bad question. So I'm trying to get from you, what else you want me to raise. Someone is asking whether a person who is involved in rigging election will lose their right to vote. Well, if they are convicted, they go to prison. So a lot of questions are being asked for me to raise the IDPADG press conference. I don't know how you pronounce this abbreviation. IDPAG. IDPAG. I think it's the Year of African Descent, an organization that was formed and that has been in the news recently. IDPAG. And some startling disclosures are in the public domain in relation to this organization. A question has been asked of me here whether other ethnic groups have any similar organization receiving such monies. Well, as far as I know, no other ethnic group in Guyana has an organization of this type, and no other ethnic group in Guyana has an organization of this type receiving this kind of public funds. What is in the public domain is that this organization has received approximately $500 million over the last 5 years from different governments. And this organization has been called upon by the Vice President to account for this money. And rightfully so. This is public funds. And I want the press, journalists who are looking at this program, to get the financial reports of this organization and interrogate it and share your findings with the public in respect of how $500 million have been spent with nothing tangible to show for it. If there is a building to which one can point, if there is even a monument to which one can point, if there is some edifice to which one can point, then, you know, that by itself can withstand scrutiny. But there is no such thing. And I have listened carefully to the press conference held by this organization. And as a Guyanese, I am not impressed at all with the explanation proffered, attempting to account for how this money was spent. I listened to some projects, some very nebulous projects, some youth conference. You don't know where it was held. You don't know how much money was spent. You don't know how many persons attended. Then I heard about some scholarship program. Again, you don't know who the children are, who are the beneficiaries of the scholarship program, which universities these students are going to or being financed to go to. Who are these persons? Was this scholarship advertised publicly so that all Afro-Guyanese children can get an equal opportunity to apply for these scholarships? No information of that type. One of the signal events mentioned is the organization and holding of a market day at Mocha Arcadia. Not the building of a market, the organization and the holding of a market day. I repeat, the organization and the holding of a market day at Mocha Arcadia. And that was listed by Mr. Vincent Alexander as one of the events that the public may know about. In other words, it's one of the more significant of the events. Now, against a backdrop of $500 million, how much would it cost to organize a market day? To organize the market day in a village, not across the country, in one village, Mocha Arcadia. And that event is identified by those who are trying to justify these expenditures as one of the signal accomplishments of this organization for which public monies have been expended. I am repeating the facts for you. You draw your own conclusions. A survey, they said, was done that cost $5 million to enable farmers to get flood reliefs. Well, I don't know. $5 million. I remember the cash for the farmers, I think, was $50,000. So $5 million was spent to assist persons to get flood reliefs. I am repeating what I heard. Counseling was paid for. 3 months of counseling was paid for, I'm told. Well, that was disclosed. 3 months of counseling was paid for the Henry family who suffered that horrible tragedy. 3 months of counseling. I don't know how many counselors and what hourly rate they charge, but only 3 months. If one counselor, and we have counselors in the government system who are public servants, so you know what their salaries are. But I don't know how much money you have to pay counselors for a 3-month period. It's just 3 months. They work monthly salaries to account for $500 million, because all of these are events identified to explain away this $500 million. And I am only putting back to you, members of the public, the events that were identified by the persons responsible for the spending of this money. And persons are here asking about that. I saw the Rastafarian Council come out with a scathing statement about this organization, saying that they were questioning those who comprise of the organization and how they were elected and how skewed, apparently, the methodologies are to select groups to benefit from this organization's financial resources. There's a statement out there by the organization, by the Rastafarian movement. And somebody drew to my attention some very scathing remarks made by Mr. Eric Phillips himself about this organization in 2018. It's in a Demerara Waves article where Mr. Eric Phillips accused the then leadership, and not much has changed, the then leadership accused them of all sorts of things. Alexander was there at the time. I think the same CEO, I can't remember her name. They were all there. And all of them were publicly chastised by Mr. Phillips. And at that time, they were occupying rental space at a property at 121 Regent Street border from Charles Corbyn. Charles Corbyn, the commissioner at GCOM of the PNC. And Mr. Phillips said then that Alexander, being a member of the commission, and this organization renting property from a co-commissioner, Mr. Charles Corbyn, might constitute or does constitute a conflict of interest. That is what Eric Phillips says. But when I examine the matter a little more closely, the leader of the opposition office is currently at this very building, 121 Regent Street border, rented from the very Mr. Charles Corbyn. So if it was incest and if it was conflict of interest for Alexander to be a member of this organization and renting a building from his co-commissioner at GCOM, what do you think about the leader of the opposition now renting the very building from his commissioner at GCOM? That is a matter for you. That is where the leader of the opposition office is. Moved out from a location they were renting at Kroll Street. Parliament was renting it and requested to move to this location. Parliament was renting a place at Kroll Street when the leader of the opposition, Mr. Harman, but when this new leader of the opposition got into office, I am told he requested to move from that location and to move to this location owned by Charles Corbyn. That is the information. You make whatever use you wish to make of it. The other issue that I want to speak about is quickly, as we are running out of time, is I spoke a few programs ago on the issue of how I offered an explanation regarding the absence of the statutory documents from the 49 boxes that the APNU AFC are making an issue of in recent times. And I disclosed that those boxes came from the locality of LBI, Better Hope, and that I was on the east coast of Demerara as the assistant chief scrutineer of the People's Progressive Party. And when it was drawn to my attention that the presiding officers of the polling stations, agents of GCOM, were not putting these documents in the ballot boxes, but were putting them in an envelope and sending them straight to the Mr. Mingo, the returning officer. I drew it to Mr. Mingo's attention the very night of the elections. And I said, and Mr. Mingo said that he is aware of it. It was a miscommunication from a few of his deputy returning officers, DROs. That is what he said. And he said that he has already informed Mr. Lowenfield. And I said also that I spoke to Mr. Lowenfield, who confirmed that he has received those documents and they are stored with GCOM's documents at Collingin. That explanation of mine apparently was carried somewhere in the press, and Mr. Vincent Alexander replied. Someone sent his reply to me. First of all, he questions why I am making this disclosure 2 years after. And secondly, he says that my disclosures leave more questions than answers. So let me deal with the first issue that he raised, why I am saying this 2 years after. The issue of statutory documents being absent from ballot boxes was not an issue until at the recount. Nobody ever made that an issue until the national recount started at the convention center. That's the first thing. So there was no basis and reason for me to speak on that issue. I thought that that was a settled matter because Mingo spoke to me about it and Lowenfield spoke about it. So it was not a contentious issue. It was when they began to fabricate and concoct objections to the recount, when they realized that they were losing, that they made that an issue. And at that recount center, they used to have press briefings outside of the convention center building, where I used to speak to the press on a regular basis. And I made that disclosure then. I made that disclosure right under that tent where the reporters were, when they were raised, and it was carried in the news. So I made it at the first opportunity that it became an issue. In fact, when I made it public and it was reported in the news, Mr. Keith Lowenfield met me the following day at the convention center because he was the chief elections officer and he was part of the recount. And he said to me that how can I disclose to the public discussions that he and I are having in person? And I had to clarify for him that whenever he and I speak or spoke on matters concerning the elections, we were not having private discussions. I was speaking to him as a representative of the People's Progressive Party, and he was the chief elections officer. And in that capacity, I was speaking to him. That if he was of the view that anything we say or said were of a private type, not for public disclosure, then he's operating under a serious mistake. Now, as I have established, the matter is now within GCOM. All Mr. Alexander has to do, if he doubts the veracity of my disclosures, is to call Mingo and call Lowenfield, persons that I know are not strangers to him, and ask them to come out publicly and contradict me. Or he can raise it as a matter for the commission to interrogate, because it's a GCOM issue. But every one of the irregularities that they are concocting and manufacturing, they want to throw at the PPP's doorstep and at the government's front door. But those are GCOM issues. And Alexander is part of the problem because he's part of GCOM. Alexander wants to wash his hands like Pontius Pilate of the issue. Though he will not be allowed to abdicate his responsibilities. They must find the documents that they were supposed to put in the box, that they had custody over in relation to the electoral process. And don't put it at my doorstep or at my political party or my government. So I am happy that Alexander responded so that I can get this opportunity to make this additional disclosure for public consumption. My reporters, my operators signaling to me that I am running out of time, but I'm trying to get to see whether you will raise another issue so that I can deal with quickly before program time. So I hope that I have again clarified these issues so that whenever they are in the public domain, persons would not be in the dark. And in any event, as I indicated, I believe last week, active arrangements are being made for the commission, for the establishment of the Commission of Inquiry announced by His Excellency the President that will inquire into the 2020 March 2nd general and regional elections. And if it is necessary, I will go before that commission to testify on this particular matter. And the last issue I want to raise about this matter is that, you know what? All these fabricated issues and these concoctions that they are now resurrecting and put in the public domain as a narrative were all examined. We often forget that, and that is why go online and get the CARICOM Observer Team report. The CARICOM Observer Team highlighted the allegations that they were making, grouped them, and dealt with them one by one, and declared them to be unfounded, without merit, specious, and hopelessly misplaced. And they use some nice language in describing them. Like this issue of multiple voting. They were standing up in front of each recounting station to make this allegation that X number of persons voted at this polling station. But when you vote at the polling station, you are ticked off. So if you look at the list of voters ticked off at that station, easily you see that what they are saying in front of those stations are incorrect. Because the names that they are calling did not vote. Their names were not ticked. Yet they're running around and speak about multiple voting. And the other issue that the government is currently investigating, and since they keep, perhaps we should have done it before, but it's not too late. We have to investigate where those statistics came from, where they listed persons as not being in Guyana. Immigration records they purported to be. Recall they wrote to the chairman of GCOM and produced names of persons whom they claimed were either dead or outside of Guyana. And we went around and found many of those persons. And they claimed those persons were in New York and that those persons voted when the persons were in Guyana. Well, the police or someone, the relevant agency, will have to investigate and tell the public where that document came from and who was responsible for compiling it and upon whose directions they were compiled. That will happen very shortly, in a matter of days. So I have come to program time now, and I want to thank all of you for joining me in yet another program of Issues in the News. I believe that we have covered good ground. We have explained and discussed a number of important issues, and I want to thank you once again for sharing your time with me. Take good care for the rest of the week. I'll be here next Tuesday again to continue this discussion. Take care. May God bless you. Enjoy the rest of the week, and of course, enjoy the remainder of this evening. Take care. God bless.